and welcome to Short Circuit. And this week, it's Short Circuit live from Chicago. We are here at the 7th Circuit Judicial Conference. It is the eve of the conference. We are at the Swiss Hotel in downtown Chicago, in the Chicago Loop. And we are looking forward to a couple days of material on the 7th Circuit, which is, in my humble opinion, the best circuit. But we'll get into why that's true and why I might be a little biased in that regard. With me here is a studio audience in Swiss Hotel in the room where we're doing the podcast, and also some wonderful guests who are experts on the 7th Circuit and are going to talk about some recent cases from the federal courts of appeals. So, as always with Short Circuit, we're going to be talking about a few cases in a little bit from my guests. But first, I'm going to introduce them, and then they're gonna say a few words about the 7th Circuit, and then we'll move on to the cases. So first, we have Sarah Konsky. Sarah is a clinical professor of law and director of the Jenner and Block Supreme Court and Appellate Clinic at the University of Chicago. And as a clinical professor there, she is right down the hall from the IJ Clinic, which is also at the University of Chicago. She, before that, was a partner at Sidley Austin, and she is a graduate of the University of Chicago. And she's practiced in the 7th Circuit for many years, but she did actually clerk on the 9th Circuit for Judge Mary Schroeder. So, Sarah, welcome to Short Circuit, and my question for you is, you've practiced all over the place, including a lot in the 7th Circuit. You clerked on the 9th Circuit. So tell us a little bit about, you have it sounds a little more well-rounded perspective. What's special about the 7th Circuit? How is it different from where appellate law is practiced elsewhere in the country? And also, does it deserve its kind of stereotype as a jurisdictional hot pot?
Thanks, Anthony. It's great to be here with you all tonight. I have had the privilege of practicing in the 7th Circuit over a course of a couple of decades now, first in private practice and now supervising students who are arguing appeals in the 7th Circuit. It's a terrific place to practice law. I agree that it's a special circuit for a number of reasons. It's a relatively small circuit, both geographically and the size of the bench. It seems, at least from a litigant's perspective, to be a collegial circuit where you can expect the judges will be engaging with each other on the issues and certainly disagreeing on the issues sometimes, but seem to have a warm professional relationship with each other. And it's also, in my experience, a circuit where you can expect the judges to be very well prepared and to be thinking about your case very hard and asking the tough questions. You unfortunately don't seem to dodge them in the 7th Circuit. But yeah, that starts with jurisdiction. I have unfortunately had cases where we've spent a lot of time talking about jurisdiction when we didn't want to be. So that happens. But at the same time, the court's going to be ready to talk about all of the different issues in the case, sometimes with a lively panel and sometimes with a quieter panel. But when that decision comes out, it's typically very well reasoned and very thoughtful, even if you're not on the winning side of it.
And next to Sarah, we have Christopher Keleher. Chris is the principal at the Keleher Appellate Law Group. He is a graduate of DePaul University College of Law. He's litigated appeals in the 7th Circuit in Illinois and elsewhere for 20 years or so. And he also, along the way, clerked for Judge William Bauer on the 7th Circuit. So my question for Chris is, if you share any words you have about the 7th Circuit yourself also, but what was it like clerking for Judge Bauer?
Well, it was a great experience. to say the least, to answer your question, and secondly, to say thank you for inviting me on the panel. I'm very flattered to be here. Judge Bauer is a very unique individual, and one of the main reasons I think that formed his worldview was I like to think that he had I'd say a foot in both camps, kind of we'll say the elites and the establishment in terms of his intellect, but he also had a foot, I would say, in the view of the common man, because he was a cab driver, he had worked at some factories, he had done a lot of just, we'll say, like blue-collar, regular jobs, partially because of family circumstances, money issues, and just timing. He had got accepted to Harvard, but he didn't go, and he stayed closer to home. He went to DePaul University for law. So I think that really formed his view, whereas a lot of other judges, and not to disparage them, but a lot of other judges didn't have that viewpoint of, we'll say, the common man again. And so when I clerked for him, he didn't say that directly, but I could tell in a lot of ways he would instill in me and my co-clerks to look at the case, not necessarily from the legal perspective. Of course, you have to do that, but to also look at it from an individual perspective, the individual litigants, and didn't always mean that he was going to rule for you just because you were the individual or because it was unfair, but he always made sure that he looked at it from that perspective and to consider that. And again, a lot of times it wouldn't carry the day, but he instilled in that to us, and I've always taken cases from that perspective, to look at it beyond the law and the fact that you're dealing with real people. And so I really appreciated getting that insight from him.
So I have a Judge Bauer story that I cannot resist telling, and it actually goes absolutely in line with how you were just describing him. I'll try to be very brief, but he was on a panel that in a case I was involved with back when I was a baby lawyer here in 7th Circuit before I worked at IJ, worked at a labor employment place, and we had an appeal. We were respondent. We were in a pretty good position, we thought, but it was after a trial, and it had to do with timesheets, how these workers filled out timesheets. And so my colleague, Steve McDowell, who was argued on our side's behalf, gets up there as respondent, and Judge Bauer starts peppering them with all these questions about timesheets and how these workers signed them and what they said and like how they, it was even like beyond the record. And so Steve was kind of like trying to answer his question as best he could, but it was hard to just give him a yes or no answer. And then he went into some other area, and then Judge Bauer goes, and I went back and listened to it. It was like 20 years ago, but they still have it on the website. He goes, "In addition to my checkered past as a part-time and piecemeal worker, I represented the sheet mail workers and common laborers." And then he goes on about how, he knows how timesheets work is what he's getting at, really. And so what was really going on in this case? And a few minutes later, Judge Rovner was on the panel, and she asked a question that related back to these other questions of my colleague Steve. And he answers, well, as Mr. Bauer was saying earlier, and then he corrected himself and said, well, Judge Bauer, sorry. And then Judge Rovner goes, well, he presented himself as Mr. Bauer, so it's okay. And that really got the sense that, to get his way through college or whatever he did, he was working construction and stuff like that.
Yes, yeah, and that perfectly encapsulates what he was about. But yeah, and just also along those lines, a very, I would say, commonsensical view of the law. And when he drafted the opinions, when we would assist in the drafting, he always wanted to try and make sure that it made sense. And so that I always appreciated that. And he also, he kept some of the other tougher judges in line during arguments. He did not like to see lawyers get belittled I'd say unless they deserved it, but not too much. So I always appreciated that he tried to keep other judges in line, because again, some of them sometimes would go over the line, and he tried to stop.
And
that,
it's only relatively recently he went to inactive senior status, right?
Yes, yeah. Which he was hanging on until the very end.
Wow.
So yeah.
Now, next we have my colleague, John Wrench, who regular listeners of Short Circuit will know. He is the Assistant Director of the Center for Judicial Engagement at the Institute for Justice, where he does all kinds of work for the center and for IJ, including writing, speaking, research tasks, podcasting. He hosts the podcast Unpublished Opinions sometimes. But he has dug into the bowels of the IJ records to report, some of our listeners may be interested, how IJ has done at the Seventh Circuit over the years. And it seems, John, that the jury is, or the panel, I should say, is still out on that one.
Yeah, I think that's right. So thank you, Anthony. It's great to be here, and it is true that the jury is out, but it's pretty interesting where we're at. I feel like we're on the precipice of like a change in our relationship, or maybe a continuation of our relationship with the Seventh Circuit. It's kind of unclear. So we have only had in our history 4 decisions issued by the Seventh Circuit. So probably, I actually haven't compared this to all the other circuits, but I don't think that's many compared to the decisions we've had. And it's not clear why that is. It could be a variety of things, but interestingly, we are 2-2 right now. So we've had 2 losses in the same case, and then we've had 2 wins on very related issues. So we have 4 cases pending right now. So it will probably kind of determine, whether we continue to have this kind of split record, or we'll see how it goes. But 3 of those cases have been argued. One of them's in briefing. And so, the next time we're here, we would probably have an update.
We'll probably be talking about some of those cases on Short Circuit
Yes.
in not too long. And definitely can find them in the Short Circuit newsletter when they come out. Well, we'll get on to the meat of our podcast today, and that is a case that Sarah is going to talk about from the Seventh Circuit. And it reminded me something that I used to know back when I did labor and employment law, which is the Fair Labor Standards Act has kind of the mirror image of what most of us learn in law school about class actions, where you have to opt into a class, not opt out of a class. And I didn't know this. The rules for how that works are not really there. And so the circuit's been trying to figure them out.
Exactly. That's a great way to lead off this discussion. The body of law we're talking about has existed for many, many decades now. But the Seventh Circuit just weighed into an issue that's been percolating in other circuits, which is what showing plaintiffs must make to procure a court-ordered notice to other potential plaintiffs in these FLSA cases that are collective actions, and in ADEA cases that borrow the same procedures. So if you're not familiar with all of these various ins and outs of these cases, I'll start with a little bit of an overview, maybe a 30,000-foot overview that will hopefully not be too painful before we move into the meat of the Seventh Circuit case. The FLSA is the Federal Wage and Hour Statute. So as you probably know, that's the statute that provides the federal law on things like minimum wages, overtime, record keeping, as we were talking about. And then the ADEA is the Federal Age Discrimination Statute that prohibits discrimination against workers who are 40 years of age and older. As an aside, that's really young. We can all agree, right? Yeah, okay. The FLSA and the ADEA both have a unique statutory language about collective actions. The statutes themselves don't say much, that an action can be maintained on behalf of an employee and others similarly situated. And then it starts to get different, that an employee actually becomes a party plaintiff when he gives his consent in writing and files it with the court to join the case. So, as Anthony was saying, this is different than Rule 23 class actions in a number of important ways. First and foremost, it's opt-in. Those opt-ins then actually become plaintiffs. So it's not like a class action in the sense that you have a representative plaintiff and members of a class. You actually have a big group of plaintiffs once you have these opt-ins. And for the FLSA, the statute of limitations doesn't automatically toll when that first plaintiff files his suit for all of the other putative plaintiffs. Strangely enough, for reasons we won't get into, it does under the ADEA toll. But as Anthony was previewing, the statute doesn't actually spell out how this works process-wise. So back in 1989, we had a case called Hoffman-LaRoche out of the Supreme Court. And the Supreme Court held that district courts have discretion to send out notice of the case to potential plaintiffs so that they are aware of the case and can decide whether they want to join, but really leaves open the rest of how this process should work. So for about 30-some years now, many of the lower courts have adopted a two-step process for these cases. If you've practiced in this space, you'll know that at this first step, once the plaintiff has filed his or her case, they'll ask the court to send out notice to everyone who's in their putative class. And many courts only require a modest factual showing that these plaintiffs are all actually similarly situated, for example, because they were victims of a common policy that violated the law. And this is a low evidentiary burden for plaintiffs. The facts of this case may help to kind of make sense of what we're talking about here. The plaintiff in our Seventh Circuit case is a woman named Monica Richards, who is in her 50s and applied for a promotion to become a district sales manager for a sales team at Eli Lilly. She didn't get the promotion, and she sued for age discrimination. She sought to then bring the case as a collective of, and I'm quoting, all Eli Lilly employees who were 40 years or older when they were denied promotions for which they were qualified since February 12th, 2022. And she alleges that all these people were similarly situated because they had been plausibly harmed by a company initiative to support and retain early career professionals. Following this approach that's been adopted by many courts, the district court held this was sufficient to send out notice to all of these plaintiffs so that they could decide whether to join the case. It didn't allow the defendants to present evidence that this proposed collective actually wasn't similarly situated. And so the case proceeds with notice going out in accordance with the normal standards. What happens next is that there's a lot of discovery in these cases typically, and then after that discovery is completed, the defendant can then try to present evidence that the case shouldn't proceed as a collective because people actually aren't similarly situated. So we've been chugging along like this for decades now. The case that many circuits have been following is a case called Lusardi from the District of New Jersey from 1987. But what makes this issue timely is that courts are starting to change course on how this process works.
That's a heck of a district court precedent, I should say.
Right? I should have looked back to...
almost 40 years.
I should have looked back at who wrote it. But 1987, Lusardi, and it's still the case that's often cited. But we now have a couple of circuits who have changed course. The Fifth Circuit has said that notice can issue at the outset only if the plaintiffs demonstrate that they're actually similar, using a preponderance of the evidence standard. And the Sixth Circuit requires a showing of strong likelihood that employees are similarly situated to send this notice. So if this is all a bit confusing so far, take a look at Judge Kirsch's excellent decision in this case, where the Seventh Circuit, spoiler alert, takes an approach that's in the middle of the approaches of the other two camps. So it's a little bit of a Goldilocks story, where the porridge is too hot, the porridge is too cold, the porridge is just right. But the Judge Kirsch opinion starts by talking about there being three core principles from the Supreme Court decision in Hoffman-LaRoche. So the Hoffman-LaRoche decision from the Supreme Court talks about the importance of ensuring that notice goes out that's timely and accurate, that the judges are engaged in judicial neutrality, so not looking like they're endorsing a collective, and that there is efficient and proper process in these cases. So we get a bit of a Goldilocks opinion where the court first concludes that Lusardi's approach is good and that it's effectuating timely notice going out to a whole lot of people, but that it is not satisfying what the court says are judicial neutrality and efficiency considerations. So, it's favoring timely notice, which is important given the running clock, especially on these FLSA claims, but the court calls it deeply inefficient because it's inviting futile attempts at joinder. By that, the court is explaining that the first plaintiff is able to send notice to a lot of plaintiffs who may end up being ineligible to join the collective. This can mean you have a much bigger case. There can be significant discovery costs for both sides, and in turn, this can increase the pressure on the defendants to settle, even though they may be confident that they will ultimately prevail in explaining that the case shouldn't proceed as a collective, for example. They may have to do a lot of discovery and undertake a lot of costs to get to that point in the case. The court also mentions that the notice may be seen as a solicitation of employees to bring suits of their own. So even if they're not eligible, it may be something that triggers in their mind a desire to file their own case. But the court, on the other end of my Goldilocks analogy, concludes that the Fifth and Sixth Circuit approaches that are more akin to a preponderance of the evidence standard don't work either, for the opposite reasons. The decision explains that the evidence needed to show that a bunch of people are similarly situated may actually reside with that bunch of people. So if you're asking the named plaintiff to show that at the outset, or the lead plaintiff, I should say, since it's a collective, that may mean that what would be a meritorious collective is basically doomed from the outset. So the Seventh Circuit takes a middle ground approach. They highlight that the watchword here is flexibility with respect to the principles outlined in Hoffman and LaRoche and the remedial goals of the FLSA and ADEA, and basically say that when Hoffman-LaRoche has talked about the court's discretion, we really mean we want to give district courts discretion. So a plaintiff must make a threshold showing that there's a material factual dispute about whether the proposed collective is similarly situated. So they need to produce some evidence, the opinion says, that they and the members of the proposed collective are victims of a common unlawful employment policy or practice. Different than what's been the standard approach, the defendants must be permitted to submit rebuttal evidence, and in assessing whether a material dispute exists, court must consider the extent to which plaintiffs engage with opposing evidence. So the court explains that they're reaching a meaningful yet appropriate evidentiary burden on plaintiffs, reflecting both the preliminary stage of the proceedings and the practical significance of notice to both parties. And if you read the decision, there's a lot of discussion about relying on the sound discretion of the district court as to how this process should unfold based on the facts of the case. Maybe it's two steps like we were talking about before, with notice and then a final determination down the road on whether the case should proceed as a collective. Maybe that determination as to whether the case should proceed as a collective could be made at the outset based on the facts of the case. And the court talks about other ways that the district courts may use their flexibility to narrow the scope of notice, deny a motion for notice with prejudice, told the statute of limitations for individuals who haven't joined yet, and more. So again, the court emphasizes that the watchword here is flexibility. If you are litigating one of these cases, or if you are an employer or employee who might be involved in one of these cases, one takeaway will be that it's going to be important to be ready to make arguments about how this process should unfold. In the Seventh Circuit, at least, it won't be a foregone conclusion that any one process is the right one. So being thoughtful about the contours of the case, the specific facts of the case, and what makes sense in light of that seem to be what the court is suggesting. It does seem that in many cases, this is going to give defendants, employers, an earlier shot at explaining why the case shouldn't proceed as the plaintiff has proposed. But perhaps in other cases, there will be, fact patterns where the plaintiff can definitively resolve this issue in its favor even earlier to its benefit. So we'll have to see how this plays out in the lower courts.
Chris, any thoughts you have about this?
I have to admit that before reading this opinion, I knew of the thing called collective cases, and that was the extent of my knowledge. So I appreciate Sarah bringing this to my attention, I should say, because I learned a lot from the opinion and from Sarah's insightful analysis. I would just add that I think, as Sarah alluded to, it's a very workable approach. Again, and I can give insight because I know nothing about it. So coming in, as a novice, the opinion made a lot of. It was very commonsensical in terms of its explanation. Judge Kirsch did a good job, and I think the approach that the court takes, the framework, I think is very workable for lower courts, which I think obviously was the lodestar there. Obviously, within the Supreme Court parameters, but as an appellate practitioner, I think as Sarah also knows, a lot of what appellate court judges are concerned about is not just, Ms. Richards or Mr. Whitaker. Obviously, they're concerned about the facts, but they also have to worry about, okay, well, what about the next Mr. Whitaker, the next Mr. Richards? And so they really have to devise a approach that is workable for lower courts, for practitioners, for litigants, basically for everybody, that they can, that makes sense and it is workable.
And this appeal, it's an interlocutory basis, but it was for whatever reasons in this case, it actually went up on appeal. And so it seemed to me kind of that the panel was like, we have a unicorn here, let's make the most of it and provide some actual guidance.
Yeah, if I'm recalling correctly, the district court certified the interlocutory appeal
Right.
in light of the Fifth Circuit and Sixth Circuit decisions and argument from the parties that the Seventh Circuit, should consider the issue. So it is a rare unicorn where you don't normally see these issues up on appeal, as Chris said.
Yeah.
John, your thoughts?
Yeah, I mean, it does. I had the same feeling that reading the opinion, it feels very realistic, like a realistic, pragmatic adjustment to a test that had kind of just existed for a period of time, and the court had an opportunity to readjust it in a way that seems, at a very intuitive level, reasonable and fair. And I'm just curious about how, if this makes its way up to SCOTUS in light of all of these splits that are emerging, whether the court is going to be more interested in a hard and fast bright line rule that's maybe a little bit less practical and maybe just a little bit more clear,
More
or whether
Papa Bear than Baby Bear.
right. So we'll see. I guess we'll see how that shakes out. And I think that will be particularly interesting because it just sounds like there's a vacuum of precedent here, right? It's been quite a long time since the Supreme Court has actually weighed in on this.
One final thought I had is there's this very humble concurrence by Judge Hamilton, which said basically, I disagree with two paragraphs on one part of the opinion. And I was just struck by this sentence. He said, the draft opines, blah, 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 citing, doesn't say the opinion, says the draft, which makes me think this was probably written in order to maybe excise those two paragraphs. That didn't happen and then never got cleaned up.
Yeah, it's funny that those were the exact thing that I was scratching my head on that. But yeah, I think that's what happened.
Yeah.
It happens when opinions go out the door sometimes.
Yep.
Well, another opinion that's gone out the door, not the way that our panelist wanted, but it was still an interesting one to read, is what Chris is going to talk about, which is a prisoner appeal that from a fellow who had some problems, but Chris thought he was not exactly treated the way he should have at the district court, and represented him at the Seventh Circuit.
Yes, thank you. So the saga of Jordan Whitaker, my client, he unfortunately has struggled with mental health issues basically from childhood. Had a very rough upbringing, to say the least, and it's continued through his adulthood. And he has a criminal history, some violent crimes. And he's been incarcerated in the state correctional facility, Dixon. And unfortunately, his issues have not abated, and his violence has been, including to others, but also self-inflicted. He's had issues with guards, he's had issues with himself, and the catalyst for this case was actually two instances of what the court would describe as self-harm. You could also call it suicide attempts. However you want to frame it, it was two instances, two separate episodes about a week apart, in which Mr. Whitaker cut himself, cut an artery on his arm, same place both times. And the first occasion, he drew significant amounts of blood, did significant amounts of damage, such that he had to be taken out of the prison and sent to the ER, which shows that these injuries were not petty. And on the second occasion, the injuries were much less, thankfully. It was still, again, a cutting. He cut himself again. So the issue was how the correctional officers responded to these two separate instances. And we argued, based on the facts, that they showed a deliberate indifference to Mr. Whitaker's health and safety. And so just, I would say a relatively garden variety Eighth Amendment claim. What made this case interesting, and to be completely honest, what shocked me, I expected this to be probably about 2 months after the argument, I get an opinion, just a firm, 8 or 9 page opinion. And I think it was 7 or 8 months, which shocked me. And when I finally got the decision, I think it was 19 pages, much longer than I expected. So what I realized was greater minds than myself, they wanted to make this case kind of an example of summary judgment standards. And what motivated the court here was the summary judgment ruling, which was obviously against my client. The district court said that there were essentially no issues of fact. And the reason I took this case in the beginning was because basically I saw there were issues of fact. The correctional officers said Mr. Whitaker was doing certain things and didn't do certain things, and Mr. Whitaker was saying the exact opposite. So that, to me, would be a natural trial issue, a genuine material issue of fact that obviously should go to a jury. So that's what spurred me to take this case for Mr. Jordan, and ultimately we did not prevail. And again, going back to the opinion, the Seventh Circuit opinion, what they took great pains to explain was there are instances where there can be issues of fact, genuine issues of fact, but summary judgment is still proper. And you may be scratching your head saying, well, that doesn't really make much sense, and that's what I said. But in the Seventh Circuit's defense, they did caution the reader, caution judges, caution practitioners that this was a rare case. And they made that point multiple times. So I think the court wanted, again, to make this case an example to show again, everyone that there can be instances where if testimony from either side, obviously, but generally from a plaintiff, is so unbelievable or is so contradictory or so convoluted, that can preclude a trial. And that can be the grounds for summary judgment, again, in rare cases. So what Mr. Whitaker and I kind of had going against us was the fact that we had no other evidence, nothing. We just had his testimony. And his testimony, unfortunately, was essentially a hodgepodge of varying, at times contradictory, at times, unfortunately, nonsensical, as to, for example, what did he use to cut himself? As I sit here to this day, I still don't know what it was. He basically said it was 4 different things. It was a fingernail. It was a piece of glass. It was a sharp item. And he said different things at different stages of the litigation. So that right there obviously didn't bode well for us. Then how did the correctional officers react when Mr. Whitaker was lying on the floor bleeding? He said they waited essentially 5 minutes. He also said that they had made various comments to him that they did not care. So Mr. Whitaker had warned these officers and they still had done nothing. So again, the court was very troubled by these various factual disagreement, or I should say factual inconsistencies that came from Mr. Whitaker. And that's ultimately what motivated the court to rule against us and to find summary judgment was proper. But again, they did take great pains to make sure that essentially, Judge Hamilton specifically, I think, knew that this opinion could be abused by municipal defendants, correctional officers, to say, well, you got this Whitaker case out here, there's a contradiction in facts, that's good enough. No. So I think that they kind of gave with one hand and took away with another hand. But it was still interesting to see that analysis, again, from my kind of, we'll say, 1,000-foot view versus the court's view, which, again, I'm only looking at it from my perspective, from my client's perspective. And the court, and me thinking, well, this is a slam dunk either way. Either going to rule for us and say, yeah, there's a issue of fact, or there's not, and just kind of call it a day. But Judge Hamilton, like Judge Kirsch in Sarah's case, he did a very good job, very thorough analysis, and took the time, as he always does. And again, ruled against me, but he at least made it clear why we didn't prevail, which I, even as a loser, I appreciate that. So that's pretty much the case in a nutshell.
John, your thoughts about it?
Yeah, so when I read the case, all I had was one big red flag of how this would be abused. And so that was my main concern, because whenever, you see a situation where a court says, yes, there are factual issues, but I don't think that they matter too much. And that's obviously not what the court says specifically, but that's the concern, is that if you were reading this case and you want to be able to use it, you are going to essentially say, you're going to want to say that there are even more situations where even though there are factual disputes, it doesn't really matter because they're contradictory. And so the thing that struck me was, it seemed like the dynamic that was going on here is that it was a unique situation where there were genuinely factual disputes. And the thing that allowed the court to kind of hang the reasoning on is the internal contradictions, specifically about what he was self-harming with. And because there was something like that to be able to hang it on, and because that fact was wrapped up in all of the other facts, the court almost looked at it as a way that it contaminated the other facts, and so it was able to say that they weren't really a problem. And so I think if there's a space where it's not clear exactly how far that goes, I think that's where it is. It's like, how much can facts about one particular thing impact other facts that are clearly in dispute? How long he was there, what he said, things like that. But I think it is good that the court knew that it was reaching a decision that certain parties are going to read, and they know what they're going to be thinking. And so I think the court did do a good job of explicitly saying this is a unique situation.
Sarah, do you think this is a case that when you're involved with summary judgment appeals, which I'm sure you are a lot, this is something that, this is the first thing to reach for if you're asking for affirmance, which is that, that there can be facts that contradict, and yet nevertheless summary judgment is granted because this is another extreme case, might be the argument.
I thought the opinion was helpful for the reasons that Chris said in setting up some, signposts for us. It is helpful to see the reiteration that an individual's own testimony can be enough to create a genuine issue of material fact. So as a starting point, you hear parties sometimes say, well, that was self-serving. It shouldn't be enough to make a genuine
That's
issue.
what a witness does. They serve themselves.
Well, it was both self-serving and true and enough to create a genuine issue of material fact. So that signpost was helpful. I agree with what the other panelists have said, that the court did seem to be trying very hard to cabin this to its unique facts. So I wouldn't want to risk overusing this precedent in saying, well, there were these, as the panelists were saying, small differences from, his testimony here to there, and that should undermine it entirely. As I was listening to the discussion of the decision, though, two of the areas that were coming to mind for me were individuals with mental illness or incapacities, and perhaps pro se plaintiffs who sometimes just aren't as artful in drafting as you would want them to be once you take the case, through no fault of their own. So I would anticipate that we may see litigation play out in those areas, especially as courts are trying to grapple with how similar they are to the fact pattern in this case.
One thing I thought of, Chris, is that this happens all the time, of course, is a witness says something later on cross-examination with a deposition, or not cross-examination, but later the attorney brings up something else, and the deponent tries to walk it back or tries to rehabilitate themselves with their own attorney. That's run of the mill, right. And we don't talk about that being, contradictory, and so there's summary judgment is appropriate. I guess the question I would have if I have a case where this precedent comes up is what distinguished that run-of-the-mill, rehabilitation of your own testimony from, what your client said.
Right. Yeah, and that's a very good point. I don't know. And ultimately, I'm sorry, I don't know. But ultimately, I think the thing that frustrated me, and I tried to make the point in the appeal, was the fact that at the end of the day, he was still pouring out blood. There was blood all over the place. So did it really, I would obviously quibble with the notion, well, whatever he used to cut himself, it worked, and I'm not laughing, but I'm just saying that it's frustrating that they didn't really fixate more on that point. And I understand, the credibility is an issue, but then obviously the rejoinder is, well, credibility is an issue for the fact finder. So, but to get to your question, I agree with you. I thought about that as well. People, and Judge Hamilton, I think, does allude to it a little bit in the opinion, that in general, parties will vacillate on things at times. So I think he did anticipate that line of thought a little bit in the opinion. But I agree with you. And as a practitioner, I've always struggled with when I see a deposition where someone does exactly what you just said, and I'm like, well, which part is the right part? Whether it's my client, whether it's the other side, whoever it is. So that's always been something interesting, especially when it's a deposition and there's a break, and obviously that they've probably sat down and said, okay, we need to fix this. So, and that's, and then that goes to the point of, well, you could create your own issue of whether intentionally or just accidentally. You could in your own deposition say X and then say Y, and arguably that's depending on the issue, obviously, and depending on the testimony, that could be in and of itself a question of fact. I know that there is many cases out there that say in an affidavit you can't create your own, but yeah, that's kind of getting really into the weeds on those questions.
Yeah.
But
Well, we're going to close with some core short circuit meat, which is an unauthorized, or was it unauthorized, search of a home and the Fourth Amendment. And we get it from one of IJ's foremost Fourth Amendment scholars, my colleague John Wrench. So, John, Seventh Circuit has served up this Fourth Amendment case. What's going on, and why is it so short circuit worthy?
So Anthony is being very generous. And it is a platter of Fourth Amendment issues. It actually, when I was reading the opinion the first time, it made me feel like I was reading like a Fourth Amendment issue spotter that involves overnight guests, and you're like overnight guests, exclusionary rule, consent, and you're just trying to pack all these things into one decision. It has all of this. It's a great thing. And it really is like Fourth Amendment opinions are really good fodder for discussion because it involves all of this different stuff and the interaction of all of this, and a lot of very interesting doctrine, which I think is clear from the opinion. So this opinion is United States versus Walker. The opinion is by Judge Pryor, and just kind of as a broad overview, I think the main issues are: what are the rights of overnight guests? What is the scope of a protective sweep, which I'll get into a little bit more, and then what, if any, of the exceptions to the exclusionary rule apply in this case? And so the kind of cast here and the setting is you have this home. It's owned by a woman named Laverne Shipp, and Miss Shipp lives there with her daughter, Ramona Paulette. Ramona has what is often an overnight guest named Richard Walker, and he's the defendant in this case. He stays there most nights, and Miss Paulette and Mr. Walker have a child who the opinion calls Walker Jr., doesn't say how old he is, but he lives with them in the home. So it implies that everybody lives there permanently except that Mr. Walker is there most nights. So what happens here is that Mr. Walker was out on supervised release. He had a GPS ankle monitor, which he removed. And so the U.S. Marshals show up with an arrest warrant. They get to the door. The door is answered not by Mr. Walker, but by Walker Jr. And the officers ask him, "Who else is here?" And he says, I don't know who else is here. And while he's talking with the officers, Mr. Walker himself comes to the door, and the officers arrest him without a fuss. So they have him on the front steps. They've arrested him. That's what they came to do. But then the officers decide that they're going to do a protective sweep of the home. And so a protective sweep, kind of stereotypical examples would be something like, you've arrested someone, but you know that there is either an adjoining room where there might be people in. You have some kind of facts to make you believe that in the house or in another space, there are not only people, but people who could potentially hurt the officers. There is a risk to the officers in the form of either a person or something else. So the officers go into the home. They end up in Walker Jr.'s bedroom, and there's a mattress that is sitting on a box spring that is sitting directly on the floor. And an officer goes over and while doing this protective sweep, he lifts up the mattress, and there is an illegal gun there. And so they take the gun, they go back outside, and while they're outside, the mother and the daughter show up at the house. And the officers show the mother, who again owns the house, they show her the gun, and then they ask her for consent to then do a full search of the home. She gives her written consent for them to do a search. They go through, including in the girlfriend's bedroom, and they find a pile of men's clothes with pills and a scale and a pipe, drugs and drug paraphernalia. So they charge him for both the gun and the drugs. And so there are two different searches here that resulted in two different things. He's charged for both of them. He tries to suppress all of that evidence, the gun and the drugs and drug paraphernalia. So in the district court, the district court says that the protective sweep was lawful. Says there are all these cases where officers go in, they're concerned, and there's even some cases that involve mattresses and like moving mattresses, looking under the bed, things like that. And so the district court says the protective sweep was fine. So that means that the gun is not getting kicked out. The court says even if the protective sweep was unlawful, we need to think about the exceptions to the exclusionary rule because maybe the gun still comes in anyways. And the court said under the attenuation exception, the gun would still come in. That exception, the kind of stereotypical example of that would be there's an unlawful arrest, and then a week later, that person who experienced the unlawful arrest goes into the police station and turns themselves in. And so it's really about whether there was an intervening act that kind of purges the unconstitutionality of the original search. So the district court says protective sweep was fine, even if it's not, there's this exception that would allow the gun in. And so the court doesn't really get into the pills and the drugs very much because they think that the consent from the owner was valid. And so on appeal, there's a few different questions before the Seventh Circuit. The first one is whether Mr. Walker has Fourth Amendment standing. That's the framing that the court uses. Has Fourth Amendment standing, whether the protective sweep was lawful, and if the protective sweep wasn't lawful, was there an exception to the exclusionary rule that applies? So this is pretty interesting, just starting with the standing thing. When I hear standing, I don't think of the Fourth Amendment. But what the court is doing when they're talking about Fourth Amendment standing here, and I've seen this more in the last 5 years or so, once in a while you will kind of see the court frame it this way, which is the court is saying, when we're asking about Fourth Amendment standing, we're asking about whether this defendant had a legitimate expectation of privacy. That sounds a lot like reasonable expectation of privacy. It sounds like we're talking about the Katz test. The Katz test is about whether there's a search or not. But the court says what we're talking about when we're talking about Fourth Amendment standing is whether the defendant had a legally protected interest, essentially, a legitimate expectation of privacy to be in this space. And so what they're actually kind of doing is they're talking about, do you have a protected interest in this? Do you have some kind of Fourth Amendment standing? And that seems to be the shorthand way of talking about that. And so like the district court did, the Seventh Circuit says, yes, overnight guests have a legitimate expectation of privacy. That's true in a hotel room. It's true in this house where you're staying in a room. The interesting wrinkle here is that because he was on supervised release, he was actually legally required to be in a particular space. He was not there. So he was not in this home.
At his mother's house, right?
It was
supposed to be?
Yeah. And so he was supposed to be there and was not there. So in one sense, even though he is where he is illegally, he also has a Fourth Amendment right to be in Miss Shipp's home because he has their consent to be there as an overnight guest. So that was a wrinkle there that I think the court did a good job of teasing apart the differences between those things. But it is a bit of a puzzle because it is illegal for you to be anywhere but this one place, but it is legal, or you have a Fourth Amendment right to be in this space. But the court does a good job of kind of teasing this apart and saying, overnight guests do have this right. And so the next question is whether the protective sweep was legal or not. And the court says there are these cases where, there's a mattress moved, an officer looks under a bed, things like that, but they are all different in a key way. There is at least some fact that the officer has been able to show in an affidavit somewhere that there was a light on and the light goes off when they open the door, or they heard people in the room and there's no one there. And now you're an officer where you're in a room where the light was on, now it's off, or you heard people in there, and now looking everywhere, including maybe even turning over the mattress, there's at least a fact there that would kind of make you think that that's a little bit more reasonable. And what the court says here is, you have a box spring with a mattress sitting on it. You don't have those facts here showing that there was some kind of risk to the officers. There was no evidence that someone was in that space, let alone someone who is actually a danger to the officer. So one of the things, and I think this is a theme in this opinion, the court is doing kind of doctrinal hygiene and drawing the boundaries to say protective sweeps not only require you to have facts, they require you to have facts that there is some kind of risk to the officers. It can't just be a person in the room, right? It has to be a person, and the officers need to have a fact showing that that person might be a risk to them. So they're kind of drawing that line there. So they say the protective sweep was unlawful, and that was the one that led to them finding the gun. And so the court moves on to saying, okay, well, was there some exception to the exclusionary rule that would still allow the gun to come in? And there's kind of three candidates here. There's the good faith exception, which is, it would essentially be the officers were good faith relying on, it could be something like circuit precedent that said it was lawful to do this search. They didn't know that they were violating the law. They couldn't have known that they were violating the law, things like that. And the court says, we just said there's no precedent that would have allowed this. So the good faith exception doesn't apply. This is an unlawful protective sweep. And there's no precedent that helps them. And so the good faith exception isn't an option. Attenuation, which is what the district court had relied on, the court said that doesn't really make sense here because attenuation, it matters in terms of timing when that happens. Here, what happens is they did the protective sweep, then they later got consent. It doesn't make sense for the later consent to be an intervening event. And so they're kind of saying you're thinking about the wrong exception. What you should be thinking about is inevitable discovery. And this is kind of a strange thing to wrap your head around, what the district court's going to have to do on remand. They're going to have to think, assuming that the later consent was valid, would it have been inevitable that the officer found the gun under the mattress? So you really have to speculate a little bit. I don't exactly envy the district court judge and having to think about this. I mean, you might be able to look at things like policy, what you normally look at, but really you have to make a judgment call on, do I think that this officer would have found this gun if not for the consent, which we're going to assume for purposes of this question was valid? And so the district court didn't make any findings about inevitable discovery. That needs to go back down for the district court to look at it. So that leaves the search that led to finding the drugs and drug paraphernalia. That was the one where the homeowner had given their consent to search. And so the thing that the panel is focused on here is the mother had been shown the gun, which was found potentially by an unlawful protective sweep. Did showing her the gun influence her willingness to give written consent?
Of course not.
Of course not. A gun under a minor's bed, maybe not, had influenced her decision to allow the officers to go, not only like throughout the house, but like her daughter's bedroom, like all these places. Yeah, so the panel is certainly thinking the right things, that, you know, there's this mother who was shown this gun that had been found. And so what the panel is saying is you got the protective sweep question wrong, and there wasn't a finding about inevitable discovery. And when this goes back down, what the district court needs to do is determine whether being shown the gun essentially tainted the consent. Because if it tainted the consent, then the second search that led to the discovery of the pills and the scales and things like that is also probably unconstitutional. And so those are the two questions that are going to go back down. And so there's just kind of a few interesting thoughts I had as a result of this decision. The first one is kind of mentioned in the beginning about standing. I think standing is a strange word to use when talking about this. Standing, like we think of standing in a particular way. But it is interesting that the court is using a standard like legitimate expectation of privacy to talk about someone's Fourth Amendment interests more than talking about whether a search occurred. It is kind of an unusual way of doing that, but I'm curious to see what's going to happen with that, like whether that will become a more common way to talk about whether a defendant has an interest that is protected under the Fourth Amendment. The second thing is, like I mentioned about what the district court is going to have to do, it's interesting to me that the things on remand require the district court to put themselves in the mind of not only of the officer who is conducting the protective sweep and thinking, if I'm the officer doing the protective sweep, do I look under the mattress or not? and then also putting themselves in the mind of the mother who is being shown a gun and being asked, do you consent to us searching the rest of the house? So it requires you thinking like other people quite a bit in a way that's it's kind of unusual, but that is what the doctrine requires here, and I think that the court did a good job of drawing those lines, which is my final comment on this is kind of each of these decisions that the panel made, I think were very thoughtful because they're all areas where a protective sweep is there's a lot of exceptions that can kind of take on a life of their own. So, right? So protective sweep is an exception. Normally you need a valid warrant, but a protective sweep is an exception to that. You have an arrest, you can do this protective sweep. And if the lines of if the scope of a protective sweep isn't policed very well, it can kind of swallow the rule, which I think the panel was very aware of here. I think the panel was very aware of how the exceptions to the exclusionary rule take on lives of their own and police those boundaries very thoughtfully, and then identified the things in which they didn't have district court analysis on and identified them and sent them back down. So I thought it was a very careful opinion that had a lot of respect for the Fourth Amendment in a way that kind of kept things from creeping while still resolving the issue in a way that I think was pretty consistent with doctrine.
Sarah, do you at the clinic have the Fourth Amendment come up in some of your cases, and in your thoughts in light of that?
Yeah, we do. Typically in cases we take on appointment, either under the CJA or otherwise. The cases are tough ones for the reasons you've been discussing. The students will often go off to research, particular exceptions to the Fourth Amendment and come back kind of wide-eyed and say, did you know this exception is so broad it allows, X, Y, or Z? And that seems to be the case in many of these doctrines under the Fourth Amendment, that maybe our intuitions don't quite match up with where the law has ultimately settled, and that these exceptions can in some cases seem like they're swallowing the rules. So I had the same reaction that this seemed like a very helpful opinion, both for explaining some of these doctrines, I thought quite well. It was like the model answer to the law school hypothetical set out by the fact pattern. But then at the same time, it seemed to be trying to carefully and thoughtfully put some guardrails around some of these areas. So, I think it's our intuition that if you lift up a mattress to look for a guy, it doesn't seem obvious that that's where you'd be looking for a guy without some reason to believe there's maybe a guy between the mattress and the box springs, which was the fact pattern in the case. But, it's not entirely obvious under some of these doctrines how these fact patterns play out. So I thought it was a helpful contribution to the body of law in the Seventh Circuit on this, on all of these issues. I agree that inevitable discovery is a really tough doctrine. We often see the government arguing it in good faith and, the other things that are argued in this case. And they're hard to grapple with, especially on an appellate record. So I'll be curious to watch this one to see how the district court tries to unpack it.
And Chris, your thoughts?
I actually have a fair amount of experience with these issues, Fourth Amendment issues. And this was the first time when you sent this case, this was the first time I had read of it. I was not aware of it. And I have to concede my first feeling was professional jealousy, that I've done, I think, at least 6 or 7 of these cases, and I am 0 for whatever it is, 0 for 7, 0 for 8. So I was happy for the PD that won the case, obviously, but these are tough cases to win for the reasons that John and Sarah mentioned. At least that's what I tell myself. But they're they're driven by the factual nuances. And I've had 2 cases, this goes back 10 or 12 years, but at least 2 cases where there were guns under the bed, under the mat. Now, I do remember there were no box springs. I remember those. I can't remember anything else, but I remember it was just a mattress and a gun under the bed. And I lost those cases. I also had a case where the gun was propped up in a doorway near a hall with 6 people, basically a flop house, and 6 people, walking in and out, and I couldn't win that one either. So, I've struggled with that issue, and more often than not, as John's insightful explanation provides, these exceptions, as Sarah says, the exceptions swallow the rules, and that's where usually I've lost. So I mean, it was nice to see for once that there was a little bit of pullback on that trend.
Well, yeah, maybe we should say here at the conference here at the Swiss Hotel, often the Fourth Amendment is a bit like Swiss cheese. It's a little bit more like maybe good American cheddar in this case. So, well, there were no holes in our panelists' analysis tonight, so I think we should give them all a round of applause. And for the people here in the room, these proceedings will be adjourned for further proceedings at the hotel bar later. But for everyone else, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.